Now, in this last 15 odd minutes, we get into that very controversial issue of the Anti-LGBTQ Bill. I wanted to know what advice the Attorney General gave to Parliament because, of course, Parliament had been sued by somebody who claimed that they had not followed the procedure in providing a financial impact assessment document. So he explained that, but he also talked generally about his views on the bill and the advice of government. So you are about to hear the official government position on the anti-LGBTQ bill, among other things.
You're welcome back. Our conversation with the Attorney General continues. We've had a lot to learn about Galamsey and his office's role in the fight against it. But that's not all get up to. Let's learn a little bit more about what you do on a daily basis. Someone has sued you. Mr. Paul Boamasefa, a farmer in the Ashanti region, has sued you and the Speaker of Parliament for not adding a financial impact assessment bill to the anti-LGBTQ bill, the members-sponsored bill that is making its way through Parliament. You're aware of this?
Yes, I'm aware of it. I heard about it on radio. Indeed, yesterday I was asked a question about it. It has still not been served on me, but now it's been served on me, served on the office of the Attorney General. So I'm aware of the pendency of such a matter.
Okay. I mean, what advice did you give Parliament on this? And did it cover this issue that this person is raising?
Yes, it covered such an issue because it's something that came to my attention. And indeed, I ought to place on record that the advice was given in context of the bill that was presented to me initially for review. At that time was designated as the Promotion of Proper Human Rights and Ghanaian Family Values Bill. Yeah. I reviewed the bill in its entirety. I reviewed it from even the title right down to the very last provision. So I conducted a clause-by-clause analysis of the bill. And my view was that, yes, fundamental parts of the bill were not unconstitutional. Some fundamental parts too were unconstitutional. And I made three broad general observations. The fact that if you look at our Constitution, which is supposed to be the yardstick against which the bill is to be measured, three major provisions stand out and constitute, in my view, the cornerstone of the assessment of any law. That is Article 12, Clause 2, which says that every person is entitled to the enjoyment of human rights and freedom set out in the Chapter 5. But of course, the enjoyment of such rights is also subject to respect for the freedoms and rights of others and the public interest. So that, for me, is the standard, that the enjoyment of your rights is subject to the enjoyment of the rights and freedoms of others and also the public interest. So any law which seeks to unnecessarily curtail the enjoyment of rights by other persons will be unconstitutional, except as such law is in the public interest. So it is not just the mere curtailment of my right which is unconstitutional, but if the curtailment of the right is in the public interest, then it's right. Then the law will not be unconstitutional. Then I also made the observation that the bill, for me, imposed certain duties on the legislature, the executive, and the judiciary, as well as on all persons, specifically relating to the setting up of prisons and treatment of a fine. And even if imprisonment was imposed, or just for a term up to 3 years. Yeah. So the government today, the MPP in 2019, sought to take the fight against illegal mining a notch higher and prescribed much stiffer punishment for engaging in illegal mining. Deletion of promotion, deletion of proper, and then also Ghanaian family values. I said there ought not to be any such thing as Ghanaian family value, because really every bill applies to all Ghanaians and all persons in Ghana. And therefore, if a person living in Ghana who is not Ghanaian is supposed to promote Ghanaian family values, is a little bit unconstitutional. It is unconstitutional because if you look at Article 26 of the Constitution, every person is entitled to enjoy any culture or to manifest any culture or religion. But there is no duty to promote such culture or religion.
No legal duty.
You have an entitlement to enjoy and maintain or profess culture or religion, but you don't have a duty to promote.
Interesting. Well, I can't wait to see that unfold. So let's the last question on this. If putting aside the court case, let's assume that gets dealt with, and this bill makes its way through Parliament.
Right.
It comes to the end of it, and it passes through, and the president now has to assent to it. Bearing in mind that it has financial implications on the government, will you advise him to assent to it?
But if it still has financial implications, my advice clearly would be that the Constitution must be respected, and Parliament's attention will have to be drawn to the fact that there are these financial implications for the taxpayer and for the consolidated fund. And for that matter, Parliament will have to take a second look at it. That is what Article 106 on the process of. So I think that the bill should have been refined to take that out. And indeed, they sought to refine it and take parts of it out. But they've still retained some part of that duty to promote and all. I think it will suffer from the same difficulties.
If I may ask, there was another aspect of the original bill that suggested that not just those who might be found engaging in LGBTQ activity, but those who might promote or support those who engage in it. So, for instance, if somebody were to say on a public forum that, oh, I don't think LGBT is a crime, that person would have fallen foul of this new law if the bill became a law. Yeah. Did you advise on that as well?
Yes, I did. I advised on every part of it. I remember advising that any bill which seeks to criminalize essentially a person's thinking may be in contravention of Article 21, which borders on ideology, right for a person to hold ideology and whatever. But again, I also advise that the part of the bill which sought to prohibit a person from publicly promoting LGBTQ is not unconstitutional. It means that if I were to go on radio advocating that there should be LGBTQ and whatever, and there is a law which seeks to prohibit that, in my view, it is not unconstitutional. Because you cannot go on radio and, of course, openly advocate the commission of crime or something that has been banned or prohibited criminally.
Okay. The actual suit that has been brought against you and the Speaker of Parliament, it has to do with some sort of financial assessment document that the plaintiff says was not included in the process. Is he correct? Was it not included?
Well, I'll come to that. I think I expressed a view of it, and for me, my honest and sincere view, which is public, is that any law which imposes a charge on the public purse must emanate from the president or a person acts on behalf of the president. That is the clear dictate of Article 108 of the Constitution.
Maybe some quick updates on the other.
Also, I think a very important part of the bill, which also touched on gay marriages in Ghana. Clearly, we again said that that bill is not unconstitutional in that regard. I mean, that gay marriages can be prohibited. But the current state of Ghana law implicitly prevents gay marriages from taking place because of the references to man and wife, man and woman, wife and husband, widow and widower, bride and bridegroom, and all that. There is no clear prohibition by the Marriages Act of Ghana. And we think that if this law seeks to make it express and to prohibit clearly gay marriages, then it's not unconstitutional. And indeed, this constitutes the position of government. I think the government of Ghana has been quite clear. The president has been quite clear so far. He's saying that not under his watch will any gay marriages take place or homosexuality be legalized. So
let's the last question on this. If putting aside the court case, let's assume that gets dealt with, and this bill makes its way through Parliament.
Right.
Comes to the end of it, and it passes through, and the president now has to assent to it, bearing in mind that it has financial implications on the government. Will you advise him to assent to it?
Yeah, but if it still has financial implications, my advice clearly would be that the constitution must be respected, and Parliament's attention will have to be drawn to the fact that there are these financial implications for the taxpayer and for the consolidated fund. And for that matter, Parliament will have to take a second look at it. That is what Article 106 on the process of enacting legislations require. That if it comes up to that point that the president has any view of it, he can refer it back to Parliament to take a second look at it.
On the other hand, with the Gregory Afoko case,